Thank you, Mr. Chair, and I know we're getting into the area where some of this stuff might be a little redundant, but I certainly believe in strong property rights, and one practice that has evolved out of PTAB is particularly concerning, which is the serial petitioning, which has been brought up numerous times already. After the filing of multiple petitions against same patent owner or even the same patent, given the high cancellation rates of PTAB, a company with multiple petitions can suffer obviously severe damage to its stock, particularly if it does not have resources to go against some of these big tech companies. At the same time, to be able to make large investments in plants and equipment, a lot of manufacturers right now need to be able to obtain accurate and reliable review of the patents that they are asserted against them. And we're also seeing, obviously, some of the shell companies that are able to purchase broad, low-quality patents, such as company MPHJ, that had the, quote, scan-to-email technology, quote, unquote, technology, and effectively holds companies hostage for some of these huge paydays that we're seeing. So it would be to everyone's advantage, I think, if you dealt with those patents quickly. At the risk of burning through my entire 3:30, I'd like, is there any way anybody would like to comment on that? I certainly would welcome that. Just describe any changes that could be made to the current system to strike a balance, which are obviously competing goals. And Mr. Kapos, if you wanted to start.
Yeah, thank you for the question, sir. I would just say the clear and convincing evidence standard that a number of us have mentioned would be a sure way to hold petitioners accountable. Further guidance through Congress modification of the FINTIV rule that's been talked about would help with the issue you've raised to avoid serial petitions, still leaving some flexibility for the PTO to be able to, I say, beg off or decline to take a challenge where a challenge has already been taken before, where a district court has already made a judgment, where the federal circuit's already made a judgment.
I can just add a couple of more ideas if it's okay. Yeah. So I think that if the PTAB would prohibit multiple petitions on overlapping claims, that would help. Also, I think that the petitioner should be required to disclose all the entities that are behind the petitioner, and all of those petitioners should be made privies to the case, and that once a decision has been made with respect to the petition, whether it's denial or institution or whatever it is, that all of those parties are then subject to that ruling.
I think that the points made by Mr. Kafos and Mr. Bright are excellent. And the only additional perspective that I'd offer is that we've gone very hard over in this balance of equities to the users of this system who are largely trillion-dollar firms. And the legal budgets here are likely a small fraction of a quarterly dividend. And to get balance back in the system, we need to think about patent owners.
I'll just add, if as long as Congress is considering changes, I might suggest adding the issue of 112B, patent indefiniteness, to IPRs. Nowadays, you occasionally get these decisions where the board is asked to review something as obvious, and they say, we have to decline to institute the petition because the claim is indefinite, and I don't know what it reads on. And that doesn't really benefit either party. That's obviously a black mark on the patent, and the claim is left forward. If the board's doing that analysis anyway as part of the institution decision, you might as well let them reach the final decision. It's a decision on the papers. So I'd recommend adding 112B to the grounds that can be raised in an IPR.
I'll just add, I think it's important for the PTAB to maintain discretion when it comes to instituting trials. I think no one wants to see abuse of the patent system, and so limiting to some degree the number of petitions that can be filed makes sense. But on the other hand, having hard and fast rules that say, oh, only one petition should ever be filed on a patent, arguably goes too far, particularly when you could have potential petitioners who are completely unrelated, and the second person doesn't get their their day to be heard. Thank you.
Gentleman's time.